Good evening. Happy Sunday. I got another email from our boy Chillie DeCastro. This is a motion for spoliation sanctions. This is from Delete Laws. You can see that it is in fact Delete Laws. There you go. Let me make this bigger for you. To delete law from Delete Laws to Delete Laws CC me and a bunch of other people, including Kate, her attorney, and I'm assuming her attorney's legal assistant. It says informing all parties tomorrow complaints to the bar. Shameful behavior from bar members. You've been notified. Respectfully, Jose M. DeCastro. And there is a motion for sanctions for spoliation attached. Oh my. Oh my. So, one thing I want to point out is this capital bar. There are sovereign citizens who believe that BAR is actually an acronym that stands for British Accredited Registry. And that's stupid because BAR is not capitalized. See, B, capital B, A R, not all caps, right? So I don't know. He's been hanging out with a lot of sovereign citizens lately, so I'm going to suggest that that's why he's doing it. So we've got the motion itself here. Plaintiff's motion for sanctions for spoliation of evidence comes plaintiff, Jose de Castro, pursuant to Federal Rule of Civil Procedure 37E, respectfully moves for the imposition of sanctions against defendant Kate Peter, her attorney of record, Benjamin J. Wish, BBO number 672743, and non-party attorney John E. Rietveld II, in quotes Rietveld, CA SBN 50543 for spoliation of evidence. Now, I have shown this multiple times. This is my California State Bar webpage. The highlighted portion there, this part right here, is my State Bar number. In fact, if you look here, if you just go to attorney search, how about this? If you just Google California State Bar attorney search. I'm helping you out, Chillie. This is how you find attorneys in California. Attorney search, the State Bar of California, MCLE self-study. You click on that. You type in the name of the attorney. In this case, it's John Rietveld. You click on search. Now, I'm the only John Rietveld who turns up. That's me. That's the city I'm active in. That's my admission date. This number right here, this is my bar number. This is my California State Bar number. If you click on the name, you can get additional information about me. So this right here is my State Bar number. It's not 50543. But anyway, he's seeking sanctions against me, so this is going to be fun. In support of this motion, I state that Peter and Rietveld destroyed relevant text evidence by using Wicker to trade non-privileged communications regarding the harassment and other claims that I bring against Peter in this action. Peter and other associates of hers, including non-party attorney Rietveld, participated in relevant communications well after they knew about this action and well after Peter was served with a complaint for this action. Wicker is a text message application that destroys messages a short time after they are viewed, or even within a time if they are not yet viewed. Uh-oh. Wicker does that, huh? Uh-oh. Plaintiff is unable to recover or replace this evidence and is severely prejudiced by its destruction. As such, the court should sanction Peter and Rietveld for willful and wanton destruction of highly relevant electronic evidence pursuant to Federal Rules of Civil Procedure 37E. This is Federal Rule of Civil Procedure 37E. We'll go over. I guess we'll just finish this first. Wherefore, I respectfully request that this court, number one, grant this motion. Number two, impose sanctions against Peter for her spoliation of evidence pursuant to Federal Rules of Civil Procedure 37E, including without limitation, by imposing an adverse inference and appropriate jury instruction. Number three, impose sanctions against non-party attorney Rietveld. Number four, impose sanctions against attorney Wish. Number five, an injunction against defendants destroying evidence. Number 6, award me the reasonable costs and expenses, including reasonable attorney fees, I incurred in securing this relief. Number 7, find defendant Peter in default under this action. Default is a specific word. Remember, default. And 8, award plaintiff any such further and general relief as it deems just and proper. And then he certifies it pursuant to Rule 7.1A2, local rule. I certify that the parties have confirmed regarding the narrow issues presented herein, and that Peter does not assent to this motion. And it's not signed, so I'm assuming, I'll be honest with you, Kate's attorney copied me into his response, but I'm not divulging any of that because I don't think that would be appropriate. I don't know if he intended to copy me on it, so I'm not going to divulge it. But I'm going to guess that since this hasn't been checked off, that they have not, in fact, conferred regarding the narrow issues presented therein. So we'll see. So anyway, let's talk about me for a second, because I like to talk about me. So can he ask for sanctions against me for spoliation of evidence? Well, let's read 37E. Failure to preserve electronically stored information. If electronically stored information that should have been preserved in the anticipation or conduct of litigation is lost because a party failed to take reasonable steps to preserve it, note that word there, because a party failed to take reasonable steps to preserve it, and it cannot be restored or replaced through additional discovery, the court, number 1, upon finding of prejudice to another party from loss of information, may order measures no greater than necessary to cure the prejudice, or number 2, only upon finding that the party acted with the intent to deprive another party of information's use in the litigation may A, presume that the lost information was unfavorable to the party, B, instruct the jury that it may or must presume the information was unfavorable to the party, or C, dismiss the action or enter a default judgment. A default judgment is different than a default. A default is an entry by the clerk stating that the time for responding to the complaint has passed. The defendant is now in default. After the defendant is in default, the plaintiff will normally file a motion to get the default judgment and will prove up the relevant things in order to obtain the default judgment. A default is different than the default judgment. The default just says that the defendant hasn't responded to the complaint in the statutorily allowed time. A default judgment is a piece of paper it's a judgment that's gained on a defaulted defendant that the plaintiff can then take and try to enforce. They're two totally different things. And Chillie's really trying for the default approach. So anyway, it obviously doesn't apply to me. Rule 37E does not apply to me because I am not a party. I am not a party. Upon finding the party acted with the intent to deprive another party of information's use in the litigation. Notice I am not a party. I have not been sued. There has been no summons and complaint served on me. I'm not a party. Benjamin Wish is not a party. And here's some other issues. Well, number 1 is it appears that Wicker is a text messaging application that destroys messages a short time after they're viewed. So Wicker sounds like, just from his pleading, is the one that allegedly would have deleted the text messages. His own pleading destroys his little case. That's a big problem. I mean, there's lots of little problems, like I don't see where he actually showed anything evidence-wise here. But then he's asking to impose sanctions against me. What does that mean? Is he seeking monetary sanctions? Is he seeking sanctions in the form of uh, evident sanctions against me? I mean, like, what does that mean? What does that even mean? He wants sanctions against Attorney Wish. What does that mean? An injunction. He's seeking injunctive relief. I didn't see that as so. These are the orders that the court is entitled to make. These are the orders, and there's no order in there for an injunction against defendants destroying evidence, especially when it's apparently Wicker that's destroying the evidence. And I'm not a defendant, and Wish isn't a defendant. Award reasonable costs and expenses, including reasonable attorney's fees. You don't have attorney fees, Chillie. You are what we like to call pro se, and pro se litigants don't incur attorney's fees. And even if you did, let's say you did have an attorney, your attorney would be smart enough to actually lay out how much he's incurred in attorney's fees, how much you've incurred in attorney's fees to get the motion done, anticipated costs for argument, oral argument or a reply brief. You can't have her found in default. He's actually should have asked for, and the court is probably going to take it as a request for a default judgment. And this is normally not a thing that the court is going to do, award any further relief than what you've asked for. But going back to me, because it's all about me, you'll see I've Googled non-party spoliation in Google Scholar. I've done lots of Googling on it, because that's what attorneys do. I don't just Google, though. I actually Google case law. This is Google Scholar is probably one of the best sites to use in case you're wondering to look things up. And there's only one case that I could really find on point. And you're going to say, well, it's a Ninth Circuit district court case. It's a district court case out of the Ninth Circuit. So it doesn't apply. Well, it kind of does apply because it actually looks at how other district courts, including district courts in other circuits, are looking at third party or non-party spoliation. So in this particular case, this is also about text messages. Employees deleted text messages. So the plaintiffs moved for spoliation. The plaintiffs moved for spoliation. And the court had to deal with, it's actually up here. So spoliation occurs when a party alters or destroys material evidence or fails to preserve evidence when the party is under a duty to preserve it. A party has a duty to preserve evidence when litigation is pending or reasonably anticipated. You notice this word party keeps popping up. Circuit courts describe the duty to preserve evidence as attaching when a party should know that evidence may be relevant to litigation that is anticipated or reasonably foreseeable. If a party had a duty to preserve evidence it did not, the court considers the prejudice suffered by the non-spoliator and the level of culpability of the spoliator, including the spoliator's motive or degree of fault. A finding of willfulness, fault, or bad faith satisfies the culpability component. A party's destruction of evidence qualifies as willful spoliation if the party has some notice that the documents were potentially relevant to the litigation before they were destroyed. There are two sources of authority under which a district court can sanction a party who has despoiled evidence: the inherent power of federal courts to levy sanctions in response to abusive litigation practices, and the availability of sanctions under Federal Rule of Civil Procedure 37 against a party who fails to obey an order or provide or permit discovery. There is scant Ninth Circuit authority squarely considering whether and under what circumstances spoliation of evidence may be imputed to a defendant who did not participate in the spoliation. The current trend among district courts appears to be to impute liability for an agent's spoliation to the principal, agent's spoliation to the principal. This is agent law, agency law, based on the traditional notions of agency law in which a defendant principal exercises control and authority over its third-party agent who possesses the spoliated evidence. A district court imputed a non-party's spoliation to a party when the spoliator was an interested third party that controlled the party's personnel file and had access to it, and was also providing the party's legal defense. Another court did the same, where not merely disinterested third party destroyed physical evidence, while on notice that litigation involved the evidence would likely ensue and could potentially be liable for indemnifying the party. I'm not potentially liable for indemnifying Kate, just so you're aware. Other district courts have declined to impute a non-party spoliation to a party where a defendant's employee destroyed a USB thumb drive to protect himself, not his employer, had not disclosed its existence to the employer, and had not consulted with the defendant company about discarding the evidence, and have observed that spoliation inferences are only appropriately entered against the party that actually destroyed the evidence. So the duty to preserve falls on the parties, etc., and spoliation, yada yada. So I am not going to be at all sanctioned for this. I just want everybody to be 100% aware of this, despite the fact that he emailed it to me. He can go, take a long walk off a short pier and get all wet and have his makeup run, because he has not done what he needs to do to get anything out of me. Now, as far as Kate is concerned, he's still going to have to show, and as far as Wish is concerned, he hasn't made any allegations to support any sanctions against Wish. But as far as Kate is concerned, he still has that huge problem of showing that she did something to destroy evidence, that she did something. Because, again, his very motion states that Wicker destroys the messages a short time after they're viewed, or even within a time if they're not yet viewed. So, I mean, just good luck, Chuck. This is a frivolous pleading. Not even taking into consideration the fact that he broadcast to the that I broadcast to the world through the email that he sent to me that he would be doing this frivolous pleading. He then went ahead and is now doing the frivolous motion. So he may be exposing himself to sanctions from the court. I would suggest to you that he is exposing himself to potential monetary sanctions from the court for bringing a discovery motion that is frivolous. So I'm not saying that the court's going to grant it because he is pro se, and courts generally take it pretty easy on pro se litigants until they don't. But there is a good possibility, there is a non-zero possibility that Jose Maria Small D. de Castro could get, in fact, sanctioned for the cost of Kate's attorney's fees. So we'll see. Thanks for watching. Have a great day.